welcome to my live show. Today I'll speak about appeal against refusal of EU family permit. I have recently seen many refusal either for EU family permit or EU settlement scheme, and just because of either for relationship issue or for uh, dependency. Now, I'll discuss today and I'll give you some bit of information how you can overcome if the Home Office refuse your application for your family permit on the basis of dependency or on the basis of relationship. I'll give you very important case law. I give you 2 3 case law, and most in, for example, in case of dependency, most of the cases they refuse you family permit on the ground that whatever money you send is not sufficient for her or him to live over here back home, or we don't trust that he or she is dependent on you because you gave a money receipt or bank statement which is, or just money receipt, you didn't send money through your bank account. So any issues, but whatever I seen from my experience is Home Office somehow bring some issue on relationship or bring some issue on dependency and just refuse the application, even though the applicant sufficiently submitted evidence according to EU policy guidelines or EU regulation. Now, in this case, if you do appeal, because recently I have couple of times regularly appeared before the court, and from my experience, what I have seen, even in courtroom, day before yesterday, I was in court and EU family permit as well as the same types of scenario. What the Home Office representative, Home Office caseworker, what they do when they see that, for example, in terms of relationship, that, for example, I produce a DNA test which show the relationship clearly, or I submitted sufficient money receipt, bank statement, still they will bring some issue on the basis of cross-examination. They will ask you questions in the court to the sponsor, and they will find some way to put forward some argument to the court, to the judge, and they will invite the judge to refuse the application or maintain the refusal letter. In that scenario, if you do represent yourself by without a solicitor, without a barrister, then the case law I'll give you today, it is very important. If you can refer this case, because this case, the European Court of Justice said it is not necessary to depend on you a sponsor fully, or it is irrelevant whether the applicant is looking for job to be self-sufficient or not, okay, or it is irrelevant why sponsor is not working in back home, or it is irrelevant, it is not an issue whether this sponsor have some income in back home to be dependent on himself. So that was the issue. Another issue, how long or how much you need to send money. That is, this question also determined by the case law, and the decision of upper tribunal or decision of court of appeal. So if your application is refused, EU family permit, because of dependency issue or because of relationship, you just don't rely on argument, or you just rely on EU immigration rules. You should be familiar with all these cases. Now, if you even mention these cases in your skeleton argument, what I do always, because some people even they don't submit any skeleton argument, but it is very useful if you can put forward some skeleton argument to the court, to the judge. Then what the judge do because when we make the submission at the tribunal, it is not possible for the judge to take notes of every single point you are raising. So it is helpful for the judge if you do submit a skeleton argument with your bundle, then judge will make a decision on the basis of this case law, on the basis of skeleton argument. It is helpful, and of course, the case law you will refer, judge will make a decision accordingly. So first things, so I'll speak about this case law and then I'll show you how you can make the appeal. Remember, in my from my experience, I'm regularly attend the court. Those who know me personally, probably you've seen, preparation for hearing is very, very important. If you are not prepared, trust me, if you not prepared yourself, even if you are a sponsor and if you want to give a witness statement, if you give evidence in the court, the tribunal, you must be familiar with the court bundle. You must be familiar with the what your lawyer will argue, what the lawyer or your solicitor try to submit. You should be familiar with that document, money receipt, the bundle, because as in court process, first, for example, if I'm a solicitor, first I'll open the case, and then I'll invite you to confirm your name, your signature, and confirm you that this is your statement. And then the tribunal judge will hand over to the home office representative. Now, home office representative will ask you many questions. This is called cross-examination. So in cross-examination, they sometimes will refer you some document from the bundle. They will ask you a few questions from this document. That's why I said you have to be familiar with the document. It is better to analyze yourself, check what is your weakness, rather than rely on your solicitor, your barrister, your counsel. You must be present, because remember, we will argue it, we will put for a legal argument, but when the home office ask question, they will not ask me as a solicitor, they will ask you. Judge will ask you question. So if you cannot give the correct answer to the court or to the tribunal, judge will suspect. Okay. And home office is sometimes I find very difficult. Even last 2 weeks before, I was in Birmingham immigration tribunal. One of my DNA test is show 99.99% accurate, and still home office try to convince the court that 1% is not matched, that means it's not a genuine relationship. So that things, you have to be addressed properly to the court. So rather, because your solicitor will not win the case, you have to win the case. So this is what the must first immediate preparation is very important. Now let me move on dependency issue first. So I'll refer you some cases, actually what these cases said. So now most of the cases, whether it was extended family member, currently still some cases going on, appeal going extended family member. Now whether the first question is whether the dependence, whether the family member need to depend on EU national fully. It is not. The decision, European Court of Justice decision, European cases. This is called Rahman case. If you Google, you will find a Rahman case. In this court said, basically, just I'll quote, the applicant doesn't need to be dependent on the EEA national to meet all or most of their essential needs. For example, an applicant is considered dependent if they receive a pension which cover half of them essential needs, and money from their EAA national sponsor which cover the other half. So this is one of the important cases. If you do some research at Abu Rahman case, you will find more important. Another case law in Monique 2011 is a UK Upper Tribunal case. Now in this case, what the court says, which determined that the support had to be meet essential needs, and if you can show that just essential needs, it doesn't need to be everything on dependent on a sponsor. And the last case, and it is very important case. In this case, it is the case is name is Ryan case versus Sweden. This is also a case from European Court of Justice, European Court, and it is very important case. Now, in this case, those whose application, I mean those application, EU family member who is refused because of dependency, you must read this case. It is very important. Reyes versus Sweden. In this case, basically, I'll just the main gist what the court said. Court found that there is no requirement for a national court to consider the reason for the dependency upon a union citizen. I said this case is very important, and I would recommend that this case is the foundation of all cases, because in cross-examination, when we see in the court, Home Office will ask the sponsor, for example, what does your parent do? Does he receive anything? Why does he not trying to get a job? Or you sponsor for your brother to come to the UK, and now what your brother does in over there? Why he doesn't looking for a job? These types of question they bring, and this types of issue they bring, and sometimes it is very common sense that you have a 35 years or 35 year young brother in back home. It is reasonable he can work and earn some money, and because of the common sense, because of this issue, you sometimes become nervous. So you have to be familiar with these types of principle, that it is according to Rai case, according to Rai and Sweden, Rai case, it is there is no requirement for the national court or any authority to consider the reason of dependency. Why the 35 years old brother is not working in the UK, not working in Pakistan or in Ghana to find a job to become a self-sufficient. It is irrelevant. It is not an issue for the courts to consider. What the court need to consider, whether the applicant is dependent on for his or her essential needs. So this is the main principle. Now, my second issue is how long basically you need to provide evidence that your the non-EU family member is dependent on you. This issue basically it is according to immigration rules and policy guidelines, 6 months is sufficient. However, I normally recommend if you can give more than 6 months, that will be better. It will give you a good position if you especially go to court. But 6 months is sufficient. So this is about dependency. Okay. I'll take your comment. I know a lot of you may asking question. If you have any question, please feel free to leave a comment. And then what I'll do after end of my discussion, then I'll give you answer. It will not be short. I'll show you next. I'll show you what is the issue about the relationship, how you can overcome relationship. And then after that, I'll show you how you can appeal. So I'll show you in the screen which form you need to fill up, what document you need to submit, and how I'll give you a bit idea what will happen at the hearing. So let me speak about the dependency issue, sorry, the relationship issue. Well, currently, if only the direct family member, I mean the close family member, can come to the UK, and close family member including durable partner, unmarried partner as well, because before 2020, 31st December 2020, durable relationship was not, or unmarried partner was not a close family member. But under current immigration rules, durable partner or unmarried partner, whether you civil partnership or same sex, opposite sex, whatever it is currently a close family member. So you can invite all the close family member. Now, relationship is a question of fact. It's not a legal question. You need to prove it by providing evidence. So one of the major issue what we see from Asia, Pakistan, Bangladesh, India, and Ghana, Nigeria, and some African country is birth certificate. Majority application refused by the Home Office because the birth was not registered one time. So either birth was registered after 10 years or maybe through 2-3 years before. So Home Office asks always, whether you born in 2020 or you born in 1995, and your birth was registered after 10 years or 15 years later, and we are not satisfied that this is a genuine birth certificate. So this is one of the common issue. Refuse. Now, if this is the scenario, I'll advise you before even you make an application, you should do a DNA test. It will not cost you much, 300 to 400 pound. You can do a DNA test, and if you submit with the application, that is resolved dependency. The relationship issue. If you are husband and wife, of course uh, your marriage certificate you should provide, and of course you should provide wedding certificate. And one of the important things you should provide is, if you are EU nationals, so you travel to back in Nigeria to get married, so you should provide your travel ticket and return ticket, and the marriage should be between this time while you are in Ghana or in Nigeria. That will remove all the suspect, all the doubt of the caseworker that this marriage was genuine, because you travel from London Heathrow to Nigeria, and then you return Nigeria to London Heathrow, and the marriage was ceremony was arranged during this time. So this is how you can overcome all the relationship issue. If you invite your parents, your birth certificate is very important. Of course, you consider DNA test. Although DNA test is not required, but however, I recommend, if your birth was registered too late, not on time during your birth, it is better to give a DNA test to avoid any further consequence or any refusal. But if you go to appeal, of course, you should take it. So this is short and brief idea. And then I next will show you how you can do appeal. Now let me make it full screen. So as you see in the screen, if you Google how to appeal against the refusal, this is the because in appeal form there are a couple of form. So you need to use the correct form. You can do appeal. Normally, we as a professional we use the My HMSCT and we do appeal. But if you do appeal by yourself, then you need to fill up IFT6 form. So if you go to government website, then you will find it IFT6. So this is the IFT6 form. So you have two options here. Either you can do online. If you click online, then here is the main everything. So what you need to do, submit an appeal. If you click submit an appeal on that section, that will open a online form. So you need to fill up this. I would recommend, if you can appeal online, you can do it. But if you can't do appeal, it is advisable also you can do paper form. Now this is the EU settlement scheme appeal. So if you click on IFT6 form, so it is available from .gov, and then this is the form you need to fill up. Now, so this is, you can download on your computer and you can fill it up. Okay, once you fill it up, you need to send it. Either you can send it by post to the first year tribunal address. Make sure you send it by recorded delivery, because sometimes the home office, the court will not receive or lost it. That happened to me, one of my client. However, I had the receipt, so I got it. Alternatively, if you don't want to post, just send it by send it by email. So I send most of my appeal is email. So this is the best method. You can email is customers.service@justin.gov.uk. In it first page, you need to pay the home office fee. You can £140 for if you make an appeal on a hearing basis. If you make an appeal on paper basis, £80. But I would recommend you should make the appeal hearing basis, because hearing is the best thing. You can go there, tell the judge what happened, you can present your case. But if it is on paper based, there is less chance. So I will not recommend to make a paper hearing. So this is the basic question you need to fill up, and then name, sponsor details. You need to write the grounds, and then what document you are giving. You need to provide the refusal letter. And refusal letter is you must give the refusal letter. It is very important. You need to give the some basic ground. But don't worry if you don't have much knowledge about a legal ground, because first you need to make appeal, and then what the court will do basically after the appeal. What the court will do basically, court will write an acknowledgement letter. First, they will take the money from your account, and their court will write a letter, acknowledgement letter. This is normally deal from the Leicester office, tribunal office, and then they will send your appeal to your local jurisdiction. So if you are London, most probably they will send it to Taylor House. However, sometimes they send it in Birmingham. Most of the hearing, I go to Birmingham court, Birmingham Tribunal. It is good. Birmingham Tribunal is very, I mean, the environment is good than London. London is more busy, more congested, but I like a lot of room available, consultation room. So you will go to anywhere. They will send your case to the local court, and then local court will write you a letter with direction. Normally they send by email. In the direction, they will ask the home office to send their bundle within, for example, 40 days, within, or 20 days, or 3 weeks, and then they will give you, once you receive the home office bundle, then you need to send your bundle with skeleton argument within next 2 weeks. This is how the home office. But in practice, home office never send bundle on time. So most of the cases they are late, and then you what you need to basically, normally what I do, before a week before the hearing, I send my bundle to the court with skeleton argument, and that has no problem, never has any problem, because this is how it works. And then in the day of hearing, you will attend to the court. Make sure you go early, prepare properly, read all the bundle, and then go to the courtroom, present your case. Within how many days you need to do appeal? If you do appeal within the UK, means if the applicant is outside the UK, so family permit, of course, it's outside the UK, then it is submit appeal within 28 days. If someone within the UK, any appeal, normally 14 days. So this is all about how to make the appeal. This is a bit of information only, and especially I focus on relationship and financial dependency, because majority of the cases they refuse because of the dependency and financial relationship. But if you can do some research, if you have good knowledge, it is very easy to win the cases. It is very easy. Hopefully, if you have any problem, you can overcome. But whatever the cases I refer, it is reasonable, and you should refer these cases to the court. So this is all about. Let me take some question about it, and then I will finish. So the question, I'll take the first question. Halaluddin, citizen of European Union will benefit from your the right direction. Thank you, Halal Bhai. May Allah bless you. Next, Jacob Stephen. Hello, lawyer. Please, on what form will all my family members apply on 7 years rule? Is it ILR-FP or FLR-FP? FLR-FP. You can use FLR-FP form. Okay. Now there is no paper-based form, so online application. Normally, if you select FLR-FP, there is the guidelines available. So FLR-FP, you need to make the application. If FLR-FP, what option should I choose? It is child or parent. Child, of course. Well, if the child apply, then child route. If parents apply, then the parents route. So normally it should be child as you apply for the child. So then YS, hello sir. Please sir, did law still allow a divorce between EU partner and non-EU partner to divorce after 3 years of marriage? And did non-EU partner live apart after 1 year live together? Thanks. Your question is not clear to me. Divorce between EU partner and non-EU partner to divorce after 3 years. It's not clear to your question, but you can divorce your EU partner or non-EU partner. But if you are looking for an answer about retained right of residence, probably your question indicate me we are looking for some answer regarding retained right of residence. That is rule is 3 years after your marriage lasts for 3 years, and then you can divorce, and then, or if you initiate, someone just submit the petition, then you can make an application to retain right of residence. And the requirement is your marriage lasts for 3 years, including UK or outside the UK, and you at least 1 year lived in the UK. So that is the requirement, and your spouse must be a qualified person and continue to live before your relationship breakdown. That is the requirement. I made a video last week. You can follow it in my YouTube and then have a look. You will get all the information regarding retained right of residence. Next question. Hello, sir. Dear sir, I want to ask a question. How many hours asylum seeker allowed to work? Those who get work permission under shortage occupation leave. As far as you can. There is no limitation that you can't work 40 hours or 30 hours. It's a full time, right? So you can work full time. Good luck. Is there any working hour restriction? No, there is no restriction regarding asylum right to work. I'll tell you one important thing for asylum seeker. Those who watching my video, most of the asylum seeker can say made a request to the home office if they don't get decision within 1 year. And this 1 year is not applicable only asylum application, it is applicable to further submission as well. And in further submission, majority of the decision take 1 to 2 years, 3 years, 4 years. This is how I got one of my client last month. I think he is from Afghanistan. His further submission is pending nearly 4 years. Alhamdulillah, when it came to me, I settled. I got his visa within 1.5 months, because I wrote very very good letter to the home office. So he got it. Probably he's watching. So further submission anyway. Now, what work you can do? This is the one of the problem. Okay, because asylum seeker, when they get the permission to work, they can work only in shortage occupation listed work. They cannot work ordinary jobs. So you can't work in restaurant as a waiter, for example. You can't work a taxi driver. You can't work in a warehouse. You can work in an ordinary crew or warehouse. You must do a work which is listed in shortage occupation list. And the good news is, currently care worker is listed to shortage occupation list. So it's a great opportunity for asylum seeker to work in care home, to work as a carer in different company, and you will earn very good money as well. So this is a great opportunity and good news for asylum seeker. I think this is a new opportunity, new field open for asylum seeker to work as it is moved to shortage occupation list. Now, this shortage occupation care worker is only 1 year scheme, and after that they'll review it. Maybe they will close it. But those who will came in the UK, who will come in the UK, who will get a work permit from the relevant company, they can continue to work until they get, probably until their sponsorship expire. So this is for all for today. I hope this information will help. If you have any question, please wait for my next session, and I'll be live. Please feel subscribe my channel wherever you're watching from YouTube, and share this information for the benefit of our brother and sister, because especially for EU nationals, because this information is very important. Thank you. Good night for today.